Thank you very much.
Mr. Silberman. Good afternoon, Your Honors. I'm going to start by showing there's been a lot of generalities, but I'll talk about the specifics of this case. If we look at PA 22, and I'm talking about the state's exhibits, that's the running of the system. That is the only FRT discovery that I've been given to date. This is the only discovery that I have. I don't know who ran the test. I don't know what make and model the machine was. These are elementary questions. The only thing I was given, and this was on motion for reconsideration, was this. And when you look at this list, okay, Tybear Miles ranks number 8. And for the first time, I've been asking what the rank scores are. And what I'm told today for the first time is that these photos are ranked in order of strength or something of that nature. I don't know. This is the first time I've heard that these are in that order. But if that's the case, Tybear Miles is number 8. So I don't know what the error codes are. I haven't been given them. I don't know what they would suggest. But if Your Honors were even to believe, and Tybear Miles has a presumption of innocence here, but if you were to believe that he was the guilty party, just for argument's sake, there's 7 other people who are wrongfully told are stronger identifiers than Mr. Miles on this list. And if you look at number 6, and that's the one that's really troublesome, I don't even know if that's a human being. The names have been redacted. I don't have them in unredacted form. That's the way they were provided to the court. But number 6 is not a human being. It's some type of avatar. My kids would call it an avatar. I don't know what you call it, but it's not a person. There's more to the story of what the state has provided you. They want to talk about the CI coming in and the CI giving information. The reports that they provide, the CI comes in on June 6th. I'm referring to PA 28, June 6, 2021 at 12:40 p.m. 12:40 p.m. If you look at the FRT runs, they're run June 6th at 12:28 p.m. Okay? They're run prior to anyone speaking to a CI. They talk about that identification isn't an issue in this case. And there's constant reference to a sister, a girlfriend, a person from the street who identifies Tybear Miles and identifies them on video. They're playing 3-card Monty with you with the videos. The state, and I give the state credit from Hudson County, tells you that there's a video of the shooting and it shows a melee of people. Understand that the record before Your Honors is not complete. The motion was made as a discovery motion before the trial court, and it was made under Artiega. The holding in Artiega said that all that was necessary was to show that facial recognition technology was used or relied upon, and you were entitled to certain information. It didn't require a showing of evidence. It didn't require me to try my case, okay? But there is significant proofs and evidence outside of the record that's before Your Honor that had that been the standard, those issues may have come up. But it puts a defendant in a very precarious situation. In order to get discovery to challenge the state's investigation, he now has to put his entire plan on the line and show the state what he intends to do. The state comes up and they tell you, Mr. Miles has enough. He has a list here, he has names, and he can ask questions about it. But the state doesn't control the cross-examination. Look, I'm here, and I know they said they're dismissing cases. I've never asked for this case to be dismissed. I've never expected it to be dismissed. When I get into the well in the trial court, I want to be able to be equipped to handle the cross-examination of how Mr. Miles was there. Because the evidence in this case isn't what they tell you. It's not, nobody identifies him as a shooter, okay? The videos are from hours before. The state comes up here and talks about the speed of FRT, and they need speed. The FRT was done June 6th. They go 72 hours later and talk to these people. How fast were they really wanting to move? So there's a lot of confusion and a lot of, I don't want to say misrepresentations, but it's not accurate. It's not accurate. And I want to be able to get into the well, not with one hand tied behind my arm and say, hey, the officer, the time is wrong here. How come your report says 12:40 and this was ran at 12:28? Oh, maybe that was a mistake. Maybe the system. Okay. There's another layer to cross-examination. Just like the state wants to corroborate evidence, they want video, they want DNA. The defense is entitled to be able to layer their cross-examination as well. And that gets into how did this happen? And I can't answer those questions for Your Honor today because I don't have any information. I don't know what, I don't know if this time is accurate. I don't know how the machine comes up with all these other people and ranks them above Tybear Miles. There's a second search that's run, and the first 5 pictures are Tybear Miles. And it says here that this is the engine's rank 1, and the other one is some other acronym, NEC. If these systems are so reliable, okay, and so effective, they're all producing different results. And there's got to be, a defendant's got to be able to challenge that and to show that there's a problem here. There's a problem here. They tell you that they gave me the photo from the Instagram. The photo they gave me is the same thing that's in the record. This is all I have, are these 4 pages. So it's not, this is not sufficient information, and the state shouldn't be able to tell a defendant what is enough for him. A trial court can tell me, a trial court can tie my hands if what I'm doing is improper, but the state comes before your honors and says, this is how it should be done, and this is all a defendant should be allowed to do. And that's, I've never heard that in my life.
Counsel,
And yes, Your
Counsel,
Honor.
in this case,
Yes,
witnesses identified the defendant from still photos taken from the surveillance videos, correct?
yes, but it's important to note which surveillance videos.
But that's how they came to the information. I'll allow you to elaborate in a second
Sure.
if you don't mind. These witnesses, regardless of how those photos were generated, these witnesses knew your client. So why is broad-based discovery of the FRT system and process appropriate in this case?
My defense theory, Your Honor, is they've taken photos
Don't
from.
give up more than you want to.
No, listen, it's all out there now. They've taken photos from what's called Kalen Grocery Store. But how they investigated the case is there was ring camera of a shooting that showed a melee of people, okay? And I don't want to go into extra record material, but there are eyewitnesses that give varying accounts of who the shooter was and varying descriptions. Once they, and their sole evidence is that Mr. Miles, they believe, is the only individual who's not running from the scene of the shooting and then jumps a fence. That's how I see it. It's very circumstantial insofar as how they're identifying him as the shooter.
But the defense that he wasn't the shooter isn't the point. I thought that the focal point of your argument was that the identification here required greater discovery, and the identification is made off of a video by individuals who very well know your client. So why under those facts are you entitled to broad-based discovery of the system?
Because it was the FRT, they as soon as the CI comes in and he says, I know who the shooter is, and I only have but reading between the lines, he says, I know who did the shooting. Fat Daddy did the shooting. They honed in on him. Okay, they reverse engineered a case. They go to Kalen Grocery Store and they get still photos that are about 90 minutes or so, don't quote me on the time, before the shooting. And then they try to hone this in on that.
But
I
you'll
want to be
argue
able-
that regardless of the use of FRT. So no matter what, if the CI comes in and says, I know it was Fat Daddy, here's his Instagram handle, here's his girlfriend's Instagram handle, here's his address, here's his girlfriend's make model of her car, and then they bring people in to identify him, no matter what, you're then arguing they didn't investigate this case. All they did was listen to the CI and then bring people in to show that defendant was on the surveillance video. That proves nothing. But none of that has anything to do with the FRT source code and why you're entitled to it here. So where is the relevance of the FRT source code to this case?
I'm going to make this very simple, Your Honor, and be candid with you. I don't know that the source code is totally relevant to me. I don't know that it is. I asked for it because Artiega allowed me to do it and said that I was entitled to it.
So, and that made you, thank you for a very honest answer. And you had earlier said in your presentation that Artiega is a bright line rule. Anytime FRT is used, you are automatically entitled to the source code.
Right.
Do you agree that that might be problematic? Why should someone automatically be entitled to proprietary source code that will mean that the state can no longer try the case just because FRT was somehow tangentially used?
And I'll be very candid in my response. When the issue came up about proprietary stuff in the trial court, my response to the state, and here they said that they reached out to various people and they had no file. I told Judge Labib, I said, Judge, I don't care if you give it to me. take it in camera, review it, and see if I need it. I trust the court and I trust them to make the decision. So I don't know if I need it. I don't know how helpful it would be in my case. But I have so little information on what's going on with this FRT. And I see that various people, someone here is innocent. I mean, the state only alleges there's one shooter. You have pages of people that are clearly innocent people, and that's a concern to me. How did we get to this situation? And
But going back to the source code, they don't have it. The state doesn't have it.
well,
Or they represent, they don't have it. They represent it's the vendor who has it. And they can't get it apparently.
I agree with you. I mean, it goes further than not having the source code. If you look at PA 27, the response from the New Jersey State Police is, we've never even had this file here. And the response from New York was the
But
same.
let's stick with this issue, this
Sure, Judge.
specific issue, because it seems to be a major sticking point. Either the current technology doesn't use source codes, or you have third-party vendors who are not parties to this case, are not the state, and are saying, no, you can't have it for proprietary reasons. Do you see how an issue like that, and I understand why you just copied the list from Artiega and used it, but doesn't it seem like there should be individualized discussion of these items, and there may be items as to which, as litigants do, you accept a representation that they have tried and they don't have it, and they can't hand it to you. In camera review is nice if the court can be handed by one of the counsel, the document or whatever it may be. But here we have the entire process held up by, for example, a source code, which is simply not something the state is going to have, apparently. I don't know the truth of this, but that's the representation.
Right, and in hearing the arguments, Judge, it seemed, if you look at the list, most of the stuff, and Your Honor alluded to it, is pretty elementary. The source code, and I think the state from the prosecutor's office alluded to that the source code seems to be the holding point. Other stuff I don't think is proprietary.
I'm not sure, there's a number of technical issues here, and it's not terribly meaningful
Right.
to me, but you see what I'm saying? Is that
I don't disagree with Your Honor that the source code is a more sensitive issue than some of the other things, which are fairly straightforward in my opinion, but I don't.
So was there any effort to do what lawyers do all the time and sit down and have a discussion about the parameters of the discovery?
Judge, so my recollection was, I made the motion, and the motion was made right after arraignment. I asked for the discovery, I was told it didn't exist, and I made a motion to compel. And in between the trial court ruling on that, the state was making efforts, and they memorialized those efforts in emails saying that they reached out. So could there have been compromise? Maybe there could have been, I don't know. But the response that I got is that nothing existed. And the only time I got anything were those pages of results with the photos. And that was in the motion for reconsideration. So up until that point, I hadn't been offered anything and I was told nothing existed. I don't really know how they got those papers later in the day. And I'm hearing today for the first time that there was discussions about other things existing, but
I think they said nothing existed from the state police. I mean, they went to HIDA for this. They didn't go to the Rock for this. They didn't go to the state police for this.
right.
So
I think it was the
Back
same
then-
response from them too, Your Honor, that there was no file. That was my
HIDA
recollection.
responding that there was no file.
That was my understanding at the trial court level, yes.
But then how did you get the,
I don't know. I don't know, Judge.
has any other court held similarly to Artiega anywhere in the country? That as long as FRT was used, you are entitled to the source code?
I don't know, Judge. That I don't know.
Anything else you'd like to present?
Just gonna. I just want to stress that pulling at the heartstrings about dismissals of cases and that stuff, this is a case that will most likely be tried, Judge. There's evidence that they can try the case on. So I just ask that in considering this, that we don't consider this threat of dismissal. There's never been a dismissal offer. There's never been one requested of me. And I think that was, you know, a cry for help from the state and saying, save us here from ourselves. They've put a technology into play that they knew would have issues, and they've done nothing to help themselves. The only explanation is that We want to keep this technology alive. And I think, as I understood the Attorney General's office, they want to keep it alive as they want it to be, which is unimpugned, unquestioned. And this case provides, just in 4 pages, questions about what is going on with this technology. And I'll put to your honors that we can't, as an overall general theory, we can't have pictures of innocent people going out to police departments and nobody's there to say who did this, who did the analysis, how did this happen? And that's what they want you to allow them to do. And that's a dangerous, dangerous proposition. It's also a dangerous proposition. The Attorney General's amicus brief argued that there's got to be a showing of a misidentification. They're turning the presumption of innocence on its head, okay? A defendant should not be required to come in front of a court and say, here is why I'm innocent. Give me the discovery that I need to show why I'm innocent. I've never seen that before. I've never heard that before. And there's a process. There's a process to go through things. There was talk that an expert hadn't been hired. They're putting the cart before the horse. RTA allowed me to make these requests absent an expert. And once I get them, I have nothing to give an expert. I give them pictures. They'll say, I need all the other 12 things. So I just ask that that the danger be noted to the defendants in this manner that the state wants your honors to consider. Unless you have any questions,
Thank you.
thank you.
Ms. Nair.